Right. So which word or clause in a mortgage pledges real property as collateral for the debt? A, accretion, B, acceleration, C, acknowledgement, or D, hypothecation. So which word or clause in a mortgage pledges real property as collateral for the debt? Sorry, copying and pasting it automatically gives me the answer.
Um,
Um,
as collateral. I want to say acceleration.
okay,
Okay.
the word I can't pronounce. Hypothecation clause in the mortgage secures the debt by pledging the real property to be the collateral for the debt. Okay, so this is, I don't even remember seeing this clause and honestly, but
Yeah,
put that response in there. And so acceleration is a clause in mortgage that allows the lender to declare the entire loan due at payable because of the default.
good to
Okay, so
know.
the acceleration, everything is due out, like this is what the mortgage or the lender is able to write in there for their clauses. And then
Gotcha.
acknowledgement is when the mortgagor signs the mortgage contract in front of a notary public. Got it.
Okay.
Okay. Yeah, that was a tough one. Half of these I don't remember either, so tune this together. Okay. Next question. A purchaser secured a loan by using a deed of trust. Now the borrower has defaulted on the loan. The trustee finds a buyer to sell the title to. Which instrument did the trustee use to convey title to the new owner? Is that A, quitclaim deed, B, reconveyance deed, C, trustee deed, or D, deed of trust? Another tough one. The purchaser secured a loan using a deed of trust. Now that the borrower has defaulted on the loan, the trustee finds a buyer to sell the title to. Which instrument did the trustee use to convey title to the new owner?
I'm stuck between either A or B. I want to say, it's the
Reconveyance
reconveyance,
deed.
but then yeah,
Answer A. Okay, so
oh,
trustee
trustee
deed.
D.
So, wow, this is a tough topic, financing.
This is the
So,
one I struggle with the most, like literally.
yeah, right. So, yeah, definitely just like writing down a quitclaim deed is commonly used to clear up clouds on title. Like quitclaim deed equals clear up clouds on title, and then deed of trust puts the title into the trust where it says until the loan is satisfied or goes into default. So they tricked you by putting in deed of trust in there. But then a reconveyance
Yeah.
deed gives title to the borrower when he pays off the loan, and then in default, the trustee is instructed by the lender to sell the property. When this happens, the trustee uses a trustee deed.
Gotcha.
Okay, good to know. Yeah, it was tough. Okay, so a buyer is late with his monthly mortgage payment. The lender could declare the entire unpaid loan amount due immediately under which clause? Is that A, the
It's
hypothecation,
acceleration.
acceleration? Okay. Is it helpful if I put the question and then the answer in there? Or
What was that? Oh
is
yeah,
it
when
helpful?
you put them in the chat.
Yeah.
Yes, yeah, it is helpful. I try to
Okay.
write. I'm like one of those people like I sometimes like my hand does hurt, I'm not gonna lie. From writing stuff down because I do that with like a lot of my flashcards and there's obviously so many that Hondros gives you.
Right.
But I do find that like I'm one of those people that like if I either say it out loud or write it down, it
Right.
does help me a lot.
Oh, good. Okay. Sounds good. I'll continue to do that. Yeah, I am the same way. Even just like typing it out doesn't do it for me.
Yeah, same. I've tried it and
Yeah.
I'm like, yo, yeah, it doesn't stick.
Yeah, right. So true. Okay, so a type of financing available for real estate mortgages in which the percentage interest rate will differ from year to year according to the terms specified by the lender is known as A, fixed rate mortgage, B, adjustable rate mortgage, C, amortized loan, or D, fluctuating loan. Percentage rate will differ from year to year. I feel like there's several names for this.
Want to say it's unauthorized loan, but then the other part of me is looking at that adjustable.
I know.
Um,
Let's just go with gut feeling. Oh, it was adjustable.
yeah, I had a feeling it was that adjustable just
Yeah.
because of it. Okay.
So, I know, right? So whenever I remember them being like back in the day when it was like the depression, they all had adjustable rate mortgages. So people were literally up and leaving their houses because the interest rate went so high that they couldn't afford their homes anymore.
Gotcha.
So kind of like now I'm like thinking about relating that. So year to year, according to the terms specified in the loan, the interest rate changes. So then
Yeah.
so then the adjustable rate mortgage is what can cause that to happen. Basically, a lot of
Okay.
people defaulting. And then where it says a fluctuating loan is not an actual loan, but a description of a loan's characteristic. So it's basically they're just trying to trick you by throwing that in there.
Gotcha. Yep, they're always trying to use those
I know. But then it's
those
like new
words.
vocab words. They're like, it's the right answer.
And I should have known that one because I know that I looked at that one. That's why I was like stuck for a minute, but that's why I
Okay.
have to stop second guessing myself. That's like one of the worst things that I do
know.
sometimes.
I totally understand. Same. So disintermediation refers to the movement of money out of savings account into a higher yield investment, an instrument used in many states in place of a mortgage, representing both parties to a transaction, or D, transferring real property by a private owner to a public agency. Which one best? Disintermediation refers to
Mm, sorry, I'm just taking the time to think about it. I want to say it's D.
D. Yeah, this is right. I
Maybe
think of
it's A.
intermediation.
Actually,
Hey,
I want to
Jocelyn.
say it may be A, actually.
A? Okay.
Yeah.
So we have Emily and
Yeah.
Jocelyn on Zoom.
Okay.
Cool. So yeah, so for some reason it doesn't, let's see. Oh, she has her she's on mute, but okay. Feel free to talk or put it in the chat. Whatever works for you guys. It's just us, so feel free to say answers out loud, put them in the chat, whatever works. And I'll see. Yay! All right.
Cool.
Good job. Cool. So that disintermediation is the movement of money out of savings account into a higher yield investment. All right, next question. An alienation clause in a mortgage refers to the clause that A, pledges the property as security to a third party, B, allows the lender to call for full payment of the mortgage because the owner sold the property. She's saying she can't hear me. Can you hear me? Emily, can you hear me?
Yes, I can hear you.
Oh, I wonder why she can't. Let me see if I ask her on mute. Can you hear me now? Hear me now.
Is
Oh, she came out. Okay,
maybe
she's gonna read it.
when she joined, I'm wondering if she clicked allow for the microphone.
Oh yeah, if you click allow for the microphone when you join. So, oh, I don't know. Good call. Allow for the microphone when you join. then I will share my login now. So an alienation clause in a mortgage refers to the clause that A, pledges the property as security to a third party. B, allows the lender to call for full payment of the mortgage because the owner sold the property. C, allows the lender to charge a penalty for early payment. Or D, calls the entire mortgage due if the owner moves outside the United States.
I think it's B.
You are correct. Good job. Which is often called the due on sale clause. The alienation clause calls the entire mortgage balance due if property is sold or transferred. Cool. So alienation clause is this equals due on sale clause.
Gotcha.
All right. Hopefully she can hear me now. Okay, next question. The provision on a promissory note or mortgage that calls the entire amount of the unpaid loan balance due upon the happening of a certain event is known as a blank clause. Is that
D.
A, de-acceleration clause? Good job. That is correct. Put the explanation in the chat. Okay. So an investor decides to take money out of a savings account and invest in a high return corporate securities. The movement of money is known as A, dedication, B, discrimination, C, disintermediation, or D, debt service. So instead of high return, the last one said higher yield.
What was that? I'm sorry. Can you repeat yourself?
Yeah, so the last that we had this question.
Yeah, I think it was
Sure.
something similar. That's what I was gonna say. It was maybe
Mhm.
disintermediate, but then
Yeah, that's correct.
okay, perfect.
Yeah.
I thought the same thing too. I was like, am I? Wasn't
I know
sure.
they just use different words and verbs. Okay, cool. Jocelyn, can you hear us?
Yes.
Okay, cool. All right.
It
So it's
worked.
just us, even though it looks like you're in here twice, but perfect. Okay. So feel free to share your answers out loud and we can just roll through these. Okay. So a person receiving an adjustable rate mortgage would expect to A, pay no interest on the loan, B, pay the same amount of interest every year, C, pay only interest every month with the principal paid in one balloon payment at the end of term, or D, see the interest fluctuate on a year-to-year basis according to the terms specified by the lender.
I want to say D.
D? All right. And that is correct. So again, with the fluctuation, year-to-year basis, and based according to terms specified, the lender is going to be your adjustable rate mortgage. Gosh, I scraped my knee this morning walking my dog. I fell and
Oh.
like I feel like I'm old with a wound. I haven't gotten a scrape in so long. Okay. So a lender charges 3 discount points on a loan. The buyer is buying a $100,000 home and is getting an 80% mortgage. How much in discount points would the borrower be required to pay? Is that 3,000, 2,500, 6,000, or 2,400?
A.
We'll say A. Maybe that quick.
No.
So it is
Close.
D. All right, and let's see how they got it. So 80% of 100,000 is gonna be 80,000, and then each discount point is 1%. So what they did is 80,000 times 3% because they had 3 discount points, and they got 2,400. Yeah, that was close because it would be you were doing it off of 100,000, so you would actually just do the 80% of 100,000, which is then
Okay,
be
that one
80,000.
got me too,
Yeah, and all these are confusing.
but I'm glad it explains it. It helps.
Mm-hmm, for sure. Oh, wow, okay. We can do another finance, or what was the other one, Wanda? Was it the licensing? Or license law?
Yeah.
Okay, cool. And Jocelyn, is this one that you want to do too?
Yeah, if
Yeah.
you have a specific one, feel free to.
Cool, yeah. I'll do this and then we can go over yours too. Oh yeah, I forgot these were 20 questions. Okay, cool. So which of the
Perfect.
following is a violation of license law? Is that A, offering training to pre-licensed agents? B, having acted as a broker without authority impeded the ability of a principal broker to perform any of the duties or impeded the ability of a management level licensee to perform the licensee's duties? C, offer a free CMA to a landowner? Or D, hire other sales people from different brokerages? So which
I want to
is a
say
violation?
B.
B, right? And that is correct. In Ohio, license law prohibits practicing real estate without a license or impeding the ability of a broker to perform their duties. An auditor appointed by the Ohio Superintendent's Office asked to review a broker's record. What must the broker make available? Is that A, sales contracts but not listings? B, sales contracts and listing contracts, whether sold or not? C, broker's personal taxes? Or D, broker's income tax returns? Auditor appointed by the Ohio Superintendent.
I want to say B.
B, yeah.
B, all right. Good job. Is correct. And it would be B, sale contracts and listing contracts, whether sold or not. Okay. An agent is advertising his own property for sale. What information must appear in any advertisements that the agent places in the newspaper? Is that A, fact that the agent is also the owner? B, rate of compensation of other brokers? C, types of agencies being offered? Or D, any close material relationship between the agent and any potential buyers? So in this, what they have to disclose, I think it's A.
Yeah, I want to say A.
All right, so yeah, so it would be A. Even though the property is a FSBO, the agent's owner-agent status must be made public. This applies to both listed and unlisted properties. Yeah, so definitely if you're selling your own property as an agent, you need to disclose that you live there.
Got it.
All right. A buyer makes an offer to purchase a house and gives the seller until midnight, 3 days hence, to accept the offer. Prior to acceptance, the buyer withdraws the offer. What is true? A, the buyer is allowed to withdraw the offer anytime prior to acceptance. B, the buyer may not withdraw the offer. C, there is a contract since the buyer made an offer. Or D, the buyer must wait until the end of the 3 days to withdraw the offer.
I want to say D. Might be A though. I don't know.
So
Any
if the buyer,
suggestions, Jocelyn?
Mm, I'll say A.
yeah, so I think it is A. So the
A.
buyer is allowed to withdraw the offer anytime prior to acceptance. So then keep in mind that this was not a contract since no acceptance has been made. This was just an offer which may be withdrawn any time prior to acceptance. So if the buyer gets cold feet and wants to back out before the seller accepts, they're allowed to do that. Even though it says like he gives him in 3 days hence, if he wants to back out before the seller even says he accepts it, he's allowed to do so. And even if the seller accepts and then the buyer doesn't know the seller accepts and backs out, that's okay too.
Okay.
Yeah. So a salesperson asks the broker return her license to the Division of Real Estate so she may transfer to a new broker. The sales agent makes a request in a certified letter, but after 10 days, the broker has not mailed the license to the division. What is true? A, the sales agent will lose her license. B, since the broker owns the agent's license, the broker may decide whether or not to return the license to the division. C, the broker could lose his license for failing to return the sales agent's license. Or D, the sales agent must wait for the broker to return the license.
I want to say C.
C.
C, correct. Good call. All right. At what point must earnest money be deposited into the broker's trust account? Is that A, within 48 hours of the terms of the contract, whichever comes first? B, immediately? C, once the offer is accepted? D, according to the terms of the contract?
Immediately.
B. B.
So
Oh,
it would be D, according to the terms of the contract.
That tricks
Or
me.
of the contract, right? So like some contracts will be like, earnest money deposited within 4 days of the offer being accepted. Some may say 3 days. So definitely in terms of the contract, and both buyer and seller have to be in agreement of these terms. So contract will take precedence because of the wishes of the parties in the contract. When advertising a listing, a broker offers buyers a $2,000 carpet allowance. What is true? A, this is unethical as the broker cannot offer inducement. B, the seller can sue the broker for fraud. C, as long as the broker discloses the inducement in the purchase contract, this is perfectly legitimate. Or D, the broker does not need to disclose this inducement because the listing is his and he is not a buyer's broker.
I want to say C.
mm, I don't know on this one.
You don't know this one, you said?
No.
Yeah, that's tough. But C is correct. So as long as the broker discloses this inducement in the purchase contract, it is legitimate. So the purchase contract needs to be agreed upon seller and buyer. So Ohio Revised Code, you don't need, just so you guys know, you won't need to know like, this is Ohio Revised Code 473.14. Like that's not gonna be necessary. But then just knowing that state that it is unlawful to offer any inducements that is not disclosed in the contract. But since this is disclosed in the contract, then it is okay.
Okay.
Okay. So a broker and seller agree verbally that the broker will assist the seller in finding a buyer. Broker then finds a buyer for the seller, but the seller refuses to pay the broker a commission. What is true? A, the broker cannot recover because the listing was not in writing. B, the seller must pay the commission. C, the sales agent can sue the seller for not paying the commission. Or D, the broker can recover under the statute of fraud. This one's tricky.
Oof, I'm thinking either B. Oh, yeah, this one is tricky.
Okay.
Because they said it verbally, so I'm trying to think like if it's verbally, I don't know if that would be legal, so it might be.
Yeah. Right, I feel like the same thing, 'cause I think.
I'm between A and B.
Yeah,
Let's
let's
see,
try A.
yeah. All right, A is correct.
go.
The broker cannot recover because the listing was not in writing. So definitely key thing to know, get everything in writing, whether it's an email, text, whatever, definitely get it in writing.
Got it.
Because verbally, like, can only take you so far when it comes to things like that.
Right.
Okay. What language does state statute require in a listing agreement? A, definition of steering. B, a statement that blockbusting is illegal. C, full legal description of the property. Or D, explanation of fair housing law. Not Ohio, sorry. Just of fair housing law. Oh, this is tricky because it's different for listing agreements than it is for like the ABA or the consumer guide. But what language does state the statute require in a listing agreement? Like I feel like A, B, and D are all good answers. Um,
I'm thinking about A, but I'm not 100% sure.
let's try A. Okay,
Mm.
so it is B. So yeah, those are, it's hard to know that so a statement that blacklisting is illegal. So definitely, so the agreement must contain a statement that blacklisting is illegal. So good to know, so that the listing agreement must contain a statement that blockbusting is illegal. And then a full legal description of the property is not required, only the address. And the definition of steering is not required under the Ohio Civil Rights Law. All right, that was confusing. Because it doesn't even say anything about steering. But that, I mean, definition of steering would also be helpful. But definitely knowing that blockbusting is illegal is required in the listing agreement.
Got it.
Okay. So when a broker does not wish a salesperson to continue with his company, the broker A must send the agent a letter within 3 days of sending the license back. B must tell the agent 30 days before sending the license back. C must tell the agent and then return the license. Or D is out of luck, the license may not be returned. So when a broker does not wish a salesperson to continue with his company, the broker does what? Really, I don't know.
I want to say C.
C? Okay.
Mm-hmm.
C?
Mm.
All right,
Oh,
so
it's
it is
A.
A. Must send the agent a
Okay.
letter within 3 days of sending his license back. Okay, so if the broker chooses to return the license, he must tell the agent immediately and also must send the agent a letter within 3 days of returning the license. Person without a license. Okay. Oh, good to know. I did not know that. Knock on wood, I don't think that's ever happened. Okay. So real estate recovery fund claims are limited to what dollar amount? Oh, I forget what this is. So the A, $800, B, $2,500, C, 100,000, or is that a million? Or D, 40,000. Okay, so it's not C because that's just wrong in how they write it. So which one is the limit to what dollar?
I want to say D.
D?
B or D. But what do you think?
I'll say
Jess?
D.
You think, did you say B?
Huh?
Did you say B or D?
D.
D? Okay. Good job.
A.
Yeah, 40,000 is the maximum amount that would be paid in the name of one licensee. 25,000, 2,500 is the amount that the real estate commission may fine per violation. And then 800 is the maximum amount of non-interest bearing loan that can be received for pre-licensing classes. And then 1,000,000 is the minimum amount that must be recovered in the recovery fund. All right, good job. That was a tricky one. Good to know those numbers for each one of them.
Yes.
Okay. What law requires a broker's license to be placed in close proximity to the Federal Fair Housing poster? Is that A, Federal Fair Housing Act, B, Real Estate Settlement Procedures Act, C, Ohio Licensing Law, or D, Ohio Civil Rights Act? So what law requires a broker's license to be placed in close proximity to the Federal Fair Housing poster?
Mm,
Wanna say feel like A is trying to throw a curveball, but I wanna say C.
Right. Oh, this is tricky.
I was thinking about D.
Okay. We're between C and D. Okay, we can try D. Okay,
Okay.
so it is D. So the Ohio license law requires that broker's license be placed in close proximity to the fair housing poster. All right, good job, guys. So the Federal Fair Housing Act mandates only the fair housing poster appear in the broker's office. Neither the Civil Rights Act nor the Real Estate Settlement Procedures Act governs the placement of a broker's license.
The
Okay.
only reason why I thought about that one was because of saying the license in the question. That's how I came up with
Yeah.
that, Jocelyn, just so you know.
All right. Thank you.
Of
Yeah.
course.
No, that was tough. And then maybe like the word law, but I guess you cannot always think because Ohio Civil Rights Act is basically a law. So
Yes.
it does get very tricky. Okay, so a broker's license would be suspended or revoked for what action? A, purchasing a homeowner's warranty for all of his sellers as a marketing tool. B, holding a raffle for a TV for all who attended his open house. C, offering a free radio to anyone who signs a 5-year lease. Or D, giving a bottle of wine to all clients who bought homes through him last year.
I think A.
Yeah, I think A too.
So
Oh,
it is
let's see.
But
so making the receipt of the radio contingent upon making the lease commitment is a violation of license law. So offering a free radio to anyone who signs a 5-year lease. So basically making them sign a 5-year lease to then give them a radio is not allowed. But as a marketing tool, paying for a homeowner's warranty for all sellers as a marketing tool, honestly, I feel like not that agents do that in our office, but I've seen that happen. So this is a confusing one, but just kind of like reversing the verbiage and being like, sign a 5-year lease to just get free radio, that is not legal. Okay. So from where does the real estate licensee get the 19 articles of canons of ethics? Is that A, the Ohio Real Estate Commission, B, the Division of Real Estate, C, the Ohio Association of Realtors, or D, the National Association of Realtors?
I always get this one wrong.
Sorry, I was reading something. From where does the real estate license get the 19 articles?
Yeah. Um,
Want to say B or D. Want to say D. I'll go with D.
so
Oh,
it is
it was
A.
A. Okay.
Yeah. So the 19 articles of canons of ethics comes from the Ohio Real Estate Commission. The
Commissions.
association promulgates a code of ethics. The Ohio Real Estate Commission is who provides licensees with ethical guidelines to be considered when a licensee is in an ethical dilemma.
Canons, commissions. That's how I'm gonna remember that one.
Yeah. Oh, good.
Mm.
Canons of ethics equals the Real Estate Commission. Yeah. Okay. A seller and broker agree upon a listing that would pay the broker a 6% commission if the broker finds a ready, willing, and able buyer for the seller's home. The broker finds a buyer who meets the seller's terms, but the seller refuses to pay the broker's commission. What remedy can the broker pursue? Is that A, sue the seller for an unpaid commission, B, file a complaint with the Ohio Real Estate Commission, C, file a suit for specific performance, or D, file a lien against the seller's residence for the unpaid commission? Oof, it's a tough one.
I wanna say, oh, this is a tough one. I wanna say A, but I don't know. Jocelyn, any suggestions?
Yeah, let me read the question one more time. September.
Yeah, it's like a loaded question.
Mhm. I'm not sure, but I will say A.
You can both kind of say, all right, let's see. A is correct. Good job. Brokers' liens can be filed only in commercial transactions against commercial real property. Only the buyer can sue the seller for specific performance. Good. So sue the seller for unpaid commission. Good job. So the lien only comes in place that can only be on commercial transactions. And then only the buyer can sue the seller for specific performance. So that's good to know for like other questions too. So what would be a violation of Ohio licensing law? A, making earnest money check payable to the seller's broker. B, making an earnest money deposit payable to a salesperson. C, making earnest money check payable to the seller. Or D, making earnest money deposit check payable to the buyer's broker. Yeah, so definitely just reading through.
I'm gonna say B. B or C.
Mm-hmm.
I was gonna say C.
Okay, let's
C.
see. So B, so making earnest money deposit check payable to the salesperson. So Ohio law specifically forbids that any earnest money check be made payable to a sales agent. Brokers have trust accounts for this purpose. Sales agents do not. So if both buyer and seller agree to make it out to the seller, then you can, but you can never make it out to your salesperson or the sales agent.
Cool.
And brokers, again, have trust accounts so that you could make it payable. But normally earnest money just goes directly to the title company. So we don't really, we have a trust account for earnest money, but we don't really use it. Okay, next. A closing occurred on September 30th, 2012. Under Ohio licensing law, the soonest the broker can dispose of the file is A, December 31st, 2012, B, September 30th, 2015, C, September 30th, 2019, or D, September 30th, 2014. So how long do you have to keep a file?
I'm gonna say it's 3 years, so I want to say B.
All right, B. Is correct. It is 3 years. The broker cannot dispose of the file for 3 years from the date of the transaction. Good job. Why is my laptop always dying? Okay, next. A buyer makes an offer to buy a house and faxes the offer to the seller in another state. The seller, upon the receipt, signs the offer, intending to mail it back to the buyer the next morning. In the meantime, the buyer telephones the seller and withdraws the offer. What is true? A, there is a contract and the seller has accepted the buyer's offer. B, there is never a rightful offer as the offer was faxed and the seller must have received the original offer. C, there is no contract as the acceptance has not been delivered to the buyer. Or D, both parties are now bound to the terms of the contract. Kind of like the one a little bit prior, so
I want to say A or B, because they signed it. So, but then he backed out. So I want to say the contract and so accept the buyer's offer, but it didn't get. This is a trick one.
so
I'll,
since sorry, go ahead.
Go ahead.
I'll say A.
Okay. So would be
Mhm.
C. So since
Because it wasn't
the
delivered.
buyer withdrew it before even knowing that the seller accepted it,
Yeah.
there is no contract yet. And the buyer would have never known that the seller accepted it because he was going to mail it back to him the
Okay.
next morning. So before he mailed it back, the buyer said that he withdraws the offer, which he's able to do because he didn't know that the seller had accepted it. Yeah, that is tricky because this is very old school. Okay, so which of the following grants the broker the exclusive right to represent the purchaser in the purchase or lease of property? Is that A, consumer guide to agency, B, exclusive purchaser agency agreement, C, agency disclosure statement, or D, buyer listing agreement? So which of the following grants the broker the exclusive right to represent the purchaser in the purchase of a lease of property?
B.
B, B is correct, yeah. This is tricky because they just kind of made up their own little agreement here, but exclusive purchaser agency agreement. So it's the exclusive right to represent the purchaser in a purchase of a lease or a property. So this could also be known as like the buyer agency agreement. So good job. Okay. A sales agent is advertising his firm's listed property in a local newspaper. The sales agent must make sure that the A, broker's name appears with equal or greater prominence than the name of the agent. B, agent's name and the broker's name are in different color type. C, agent's name and broker's name are in the same font. Or D, agent's name and broker's name are the same size.
A.
A2.
All right, good job. And A is correct. Okay, sorry guys. Wait, this doesn't end. Oh, I guess I can. Okay, okay, so let's start, oops, let's go back to home. Okay, hopefully that my thing doesn't end prior. Oh, I gotta grab my charger real quick, one sec.
Okay. Jocelyn, do you have a specific topic you want to focus on that you've been struggling? I've done the first two, so I don't mind you picking this one out now.
I mean, I would like to go to financing again.
Okay, we can do that one.
Yeah.
Yeah, that was one I struggle with too, so it'll help me out again.
Yeah.
With pressure.
Well, all right, I'll do one more. Which one are you thinking?
Financing.
Financing? Okay,
Yeah.
sounds good. Okay, so a lender wishes to make the yield on a lower than market interest rate loan competitive with higher interest conventional loans. What would the lender charge in order to make the loan more competitive? A, penalty points, B, deed in lieu of foreclosure, C, discount points, or D, debt service. Okay. Discount points are charged by lenders to make a loan on a loan market rate loan more competitive. The discount points is going to be what they would want to charge. Good job. Next, a potential borrower lives in a title theory state when it comes to lender financing. Which type of instrument would a potential borrower give to the bank in order to obtain the loan? Is that A, deed in lieu of foreclosure, B, deed of reconveyance, C, mortgage, or D, deed of trust?
D.
You said, sorry, you kind of broke out. What was that?
D.
Deed? Deed, a deed of trust is correct. Good job. Deed of trust is an instrument used in many states in place of a mortgage. All right. A property description that uses natural monuments and markers and has a beginning and ending at the same point is known as A lot and block description, B government rectangular survey, C meets and bounds description, or D recorded plat of subdivision.
C.
You're going to say meets and bounds? And C is correct. Good job. So meets and bounds legal description starts at beginning point and the description of the property's boundaries and the returns of point of beginning. Good job. POB, point of beginning. I feel like they use that abbreviation. Okay, so an additional loan fee charged by lenders to make the yield on lower market interest rate loans competitive with higher interest conventional loans is called what? The A, disintermediation, B, debt, C, a discount point, or D, debt service. So we actually just got this one.
D.
So it would be, C. So the discount
This.
point,
Okay.
yeah, so that's what they, to make their loans more competitive, that's what they would choose.
Okay.
So discount point is what lenders would choose. Bye, you too. Yeah. Okay, so a homeowner's property has been foreclosed upon the bank and sold at a public auction. The homeowners own $50,000 on the mortgage, but the property is sold for only $40,000. To collect the $10,000, the lender could A, file a deed of trust, B, ask for dedication, C, obtain a deficiency judgment, or D, file a deed in lieu of foreclosure. This one's tough. Okay, so like I said, C, let's see. So C is correct. A deficiency judgment is the mortgage debt that remains due and payable by the borrower after the share of sale of property. Good job. That was a tough one. Okay, next. George has been turned down by 3 lenders and finds one who will make the loan if he will pay 2% more in interest than the statutory limit. The lender is guilty of A, usury, B, violating RESPA, C, impressing the boss, or D, violating the Fair Credit Reporting Act. So whenever I copy and paste, it always chooses C. So impressing the boss, I mean, maybe he's doing that, but
Um, either B or C. I mean D.
right? B or D. Let's see. Oh, it's actually A.
Oh,
So a
it's A.
lender who charges more than the statutory limit of interest is guilty of usury. But I did not remember that definition, but good to know. So that is what? So a lender who charges more than the statutory limit of interest is guilty of usury. I don't even know if I'm saying that right. That was hard. Okay. Payment of debt in regular periodic installments of principal and interest is referred to as a blank loan. So payment of debt in regular periodic installments of personal and interest is referred to as a amortized loan, assumption of loan, assignment of loan, or straight term loan. So payment of debt in regular periodic installments of principal and interest is referred to as a type of loan. Right. So A is correct. So A, amortized loan. So payment debt in regular periodic installments of principal and interest referred to as amortized loan. So let's see, amortized loan involves payment of debt, regular periodic installments of principal and interest. An assignment and an assumption refers to giving and taking the liability for one party another under a mortgage. And then the straight term loan involves interest only payments, usually with one balloon payment at principal at the end. That's tricky, but where did they give a description of that? Okay. So an instrument used to transfer title from a trustee to the equitable owner of real estate when title was held as collateral for security of a debt is most often called a deed. Is this A, in lieu of foreclosure, B, of reconveyance, C, of trust, or D, of restriction?
B.
B, and B, correct, good job. So an instrument used to transfer from a trustee to equitable owner of real estate when title was held as collateral for security of a debt is most often called a deed of reconveyance. Good job. I did not know that. Okay. The term amortization refers to A, interest-only payments over the life of a loan, B, repayment of a loan by principal payment only, C, a balloon payment at the end of a loan, or D, payment of a debt in regular periodic installments of principals and interest.
I will say
D.
C.
D. D is correct. So amortization refers to the payment of debt in regular periodic installments. Good job. All right, one more question. The primary function of the secondary mortgage market includes all the following except A, sell real estate mortgages, B, make loans directly to the public, C, buy real estate mortgages, or D, provide great liquidity for mortgages? Gosh, I feel like I had something similar on my test. The primary function of the secondary mortgage market includes all the following except what?
A.
Okay, so it'd be B. So secondary markets are the private investors and government agencies that both buy and sell real estate mortgages. So they don't make them directly available to the public. Okay, good job, guys.